Hi, everybody, and welcome back. Today we're going to talk about the strategic use of alibi defenses and how alibis are used in courts, with really taking the perspective of the defense attorneys here, but we'll talk about prosecutors some a little also. So if you're interested in the Duke lacrosse case, which I strongly suggest you should be, you should watch these three YouTube videos to get some kind of greater context on what we're about to talk about here, and they're linked right there. So in the spring of 2006, Crystal Mangum was accused three members of the Duke lacrosse team of rape. She was hired there to work as a stripper at a party, and a media firestorm erupted due to the race of the offender victim and the differential wealth of the parties, right? So we see down here are the three gentlemen that were accused of raping Crystal Mangum. Here's Crystal Mangum up here. These are three Duke lacrosse players, fairly affluent white males who sexually assaulted allegedly a African-American female who they hired to work as a stripper, right? Eventually, though, the story fell apart when one of the accused provided an alibi that was heavily corroborated by evidence, right? And the whole case kind of fell apart. This is actually an alibi case, not technically because the guys were never formally prosecuted for this, but they had their reputations pretty heavily damaged. The head coach for Duke's lacrosse team got fired. There was a lot of drama that ensued because of this fake claim of sexual assault. Alibi evidence can be used to poke holes in a prosecution's story. And so, before we talk about that, what in the world is a prosecution story? So basically, in court, each side tries to tell a story and use the evidence as support for their story, and the side whose story is more believed is the side that's going to win, right? The story is more believed typically based on the evidence that's provided. So while this may cause one to believe that alibi evidence is the holy grail of evidence, it ruins the alibi's or the prosecutor's story and says the defendant couldn't have done it. Alibis are very rarely successful. Why are they unsuccessful? Well, we've spent the whole semester talking about this. Obtaining evidence is difficult. Convincing a jury to believe the alibi is difficult. There's also alibi notice rules, and this requires the defense to share details of the alibi with the prosecutor before trial. This allows the state then to reframe their story to account for that evidence, or it allows them to marshal rebuttal evidence to refute the alibi claims and the corroborators, right? So as a note in this lecture, Levine and Miller, in their chapter in Alibis and Corroborators, surveyed practicing and retired defense attorneys about their alibi use and perspective. They surveyed attorneys from all over America with a variety of experience levels. 85% had 11 plus years of experience, and 45% had indigent clients. They documented concerns and challenges that they faced, and this is where you'll start to see law in theory versus law in practice. We have all these ideas about alibis. Oh my gosh, all any defense attorney has to do is get an alibi. If they can find an alibi for their client's going to walk. Well, that's true in theory. In practice, maybe not so much. So, the legal definition of an alibi defense rests on the notion that the police have arrested the wrong person, right? Since the accused was at a different location. It is not an affirmative defense, but rather a challenge to the prosecutor's burden of proof. Technically, you could use an alibi defense by simply just saying, I wasn't there, right? However, a stronger defense is one that where the claim is made and supported by readily observable evidence or witnesses. So, an affirmative defense is something like self-defense. Yes, I shot the person, but I shouldn't be convicted for it because it was self-defense. An alibi defense is saying, no, it wasn't me. I didn't do it. I had nothing to do with this. Defense have different strategies they can use with alibi evidence. Alibis can be presented to police, to prosecutors, or to judges and juries, right? When to present that evidence can have some advantages to a suspect. However, it can also have some disadvantages. If it's presented too early, the prosecution has time to challenge it and dig up dirt on the alibi witness. Why would a prosecutor do this? We'll talk about that in a second. If you wait to raise it until trial, a client may be in jail for months or years unnecessarily, right? And so, we'll talk about why a prosecutor would dig this up in a few slides, but jurors also find an alibi presented in court unbelievable because it must have been investigated and found to be untrue if it actually made it all the way to the trial. So in a survey of alibi timing, defense attorneys take an alibi claim to the prosecutor if, and only if, in 20% of the cases, there's strong person or physical evidence to support the claim, The facts of the case are such that it would warrant bringing the alibi. The prosecutor, if they have a reputation for fairness and working with the defense, 12% will take the alibi claim. And 12% will say if they have a pre-existing professional relationship. Interestingly, the seriousness of the crime, the defendant's criminal history, and a professional relationship with the judge didn't really have anything to do with this, right? So one participant in this survey said if an alibi is solid and it can be proven by independent and outside sources, which is important, independent and outside sources, so that almost sounds like non-motivated strangers, then I always favor presenting it to the DA before trial. However, if the alibi depends on testimony from a witness that the DA's office can find and lean on with threats of violation of probation or calling the Department of Family and Children's Services on their children, then I tend to play those cards a little closer to the vest. I may spring that alibi on the state 10 days before trial and see if my witness can hang in there long enough to testify. This goes back to that previous slide where the question was asked, why would a prosecutor dig up dirt on an alibi? What if the prosecutor just is convinced that they've got the guilty party? And then all of a sudden the defense attorney comes in and goes, not my guy, here's the alibi evidence. Well, that doesn't work. I've just spent hours of my time, possibly weeks or months, pinning this case on this defendant. I know this guy's the guilty party. Let's check and see if they're out on probation. And if they are, we'll arrest them because you can't testify from jail. Let's call up the person and say, hey, the Department of Children and Families is going to come in and check and see if you're good to your kids or not if you keep going with this case. Drop it and let me get my conviction. That should really, really concern us, right, as we're listening to this, right? It's ignoring evidence that suggests someone is innocent in order to get a conviction just because of a belief that that person is guilty. And this is what a defense attorney said. And even still, they said, spring it on the state 10 days before trial. And we'll talk about what alibi notice rules are in a couple minutes. But wait till the last possible minute and see if my witness can hang in there long enough to testify. 10 days? That's not a very long time. And you're going to see if they can hang in there long enough? Whew. That should be very concerning to all of us. So legal proof standards. The defendant bears the responsibility for raising the alibi claim. It's not the prosecutor's job to say, hey, we think you might be innocent, right? That's the defense's job. However, the prosecution must disprove the claim beyond a reasonable doubt in trial. Therefore, there's no formal legal proof standard required for police or prosecutors to investigate the claim. In fact, 75% of prosecutors said they would proceed with the case even with an investigated alibi claim that seemed to be true, because they say it's not their job. That's for the jury to decide. My job is to prosecute you. My job is not to figure out if you're innocent or not. That's the jury's job and the defense attorney's job. So even if you bring me a claim that seems very, very reasonable, let's let the jury decide how reasonable it is, right? Police and prosecutors may even turn the investigation to the corroborator and attempt to violate or threaten them with perjury charges for corroborating, right? So not only are prosecutors actively saying it's not my job, they might actually inhibit a corroborator from testifying by threatening them with charges of their own. Alibis rely on specific claims about the crime in order to provide any specifics about the alibi claim, right? You have to say you were at a different place at the same time as a crime. This requires the police, though, to report with accuracy the specifics about when and where a crime took place. And some police reports will do that, right? They might say, like, at 6:09 a.m., the Zales jewelry store on US 1 was robbed. Others might not be quite as specific, like between 2 and 4 a.m., or sometimes around midnight. Well, that seems like, it's like, okay, well, maybe they're just trying to, it's a window, they're not really sure, it's hard to nail down times. Well, sure, that's fair enough, right? There's no question with that, fair enough, right? But the problem is, the fuzzier the time frame, the more difficult to provide a complete alibi, because instead of remembering a specific time, a suspect has to account for a block of time. And any unaccounted for gap in that time frame looks suspicious to the police, right? So between 2 and 4 a.m., I can look at my Zoom doorbell and say, look, no one came in and out of my house between 2 and 4 a.m., but here's video footage of me going in at 8 p.m. and leaving at 6 a.m. So between 2 and 4 a.m., I had to have been inside. If someone said sometime last night, well, now I've got to account for a whole lot more time. and any unaccounted for time might make me look suspicious. Time and location play a role in the quality of evidence, such that 87.5%, suspiciously very close to 90%, said that the client's ability to be specific about their location was heavily or moderately influential in using the alibi by defense attorneys. With alibi claims, defense attorneys also are trying to distinguish between true and soft alibis, right? True alibis have specific location and time evidence, where soft alibis have general time and location evidence. Where were you 2 weeks ago? Generally, I live on the island. I was hanging out around the island somewhere. I may have been home. I may have been at my friend's house. That's a soft alibi. True alibis were, here's where I was. Here's the security camera footage. I know for a fact where I was. The larger the gap in the police report, the more creative the prosecutors get in developing their story, right? Police may even extend timelines to make an alibi more difficult to support, right? So we think it was between 2 and 4 in the morning. Let's just say sometime overnight. Well, what's overnight? Well, night starts at 8 and it ends at 8 a.m., 8 p.m. to 8 a.m., instead of between 2 and 4 a.m. 75% of respondents said that they believe the police and prosecutors will sometimes or frequently blur timelines in order to make it harder to provide an alibi. Not a single defense attorney said that it never happens. There's also some, and granted, I've been fairly critical of prosecutors here. So if you're looking at this saying, golly, boy, this guy's got a bias, doesn't he, against prosecutors? Well, I've got some stuff to say about defense attorneys too. Don't you worry, right? There's the alibi literature versus survey results, right? The survey says, if it's a mom or a girlfriend, I don't use it. They always lie. And a defense attorney said that, right? The defense attorney even said, I don't believe them if it's a motivated familiar other, basically, because people are always willing to lie to help their family out, right? And this is your advocate as the suspect. The person who's supposed to fiercely defend you is saying, nah, I don't even bother with it because they always lie. Another survey respondent said that their client had an alibi. The problem was it was for selling drugs. It's probably true, but confessing to felony drug sales wasn't going to be a major improvement over the assault charge at issue, right? So, yeah, they probably didn't do this thing they said they were doing, but might as well let them get charged for assault because drug sales and assault charge are about the same punishment, so they're going to get punished for something. Why not just let them get punished for whatever the police want to punish them for, right? Now, of course, what's the problem with that? They get punished for the assault, and then they're found to also have been selling drugs. Are they going to get punished again for the crime they actually did? Possibly. Greater relational difference also, according to some, suggests that they're more likely to forget. Right? Unlike an eyewitness to a crime, an alibi witness has no reason to realize when they interact with the defendant that they will be asked to recall him or her later. The alibi witness may have interacted with dozens of people during the critical time and may not recall which customers were there at that time, right? So the idea here is, well, it's really, really hard to get a stranger to actually corroborate your alibi because why in the world will they remember you if it was an insignificant thing? So let's think about that for a second. The defense attorneys say, if it's a mom or a girlfriend, I don't use them. They always lie. But if it's a stranger, they have no reason to even remember you, so it's probably not going to be helpful. What in the world does that mean for person evidence? It's really, really hard to get good person evidence then, isn't it? 91% of survey respondents said that strong physical evidence was heavily or moderately influential in the decision to pursue an alibi claim. Interestingly enough, this even includes ankle monitoring. Whether we want to accept this or not, or whether we're aware of this or not, there is often times that the police will go with the quote-unquote usual suspects, right? Oh, this guy always commits crimes like that. Let's go check him out. And so someone who has a long criminal record might continue to get interviewed for future crimes. Sometimes that criminal record, in the form of having an ankle monitor, right, is actually helpful and can be used as alibi defense. While the burden is on the prosecutor to disprove the alibi claim, 83% of survey respondents believed the defense must present extremely convincing or moderately convincing evidence in order to prevail. So defense attorneys say, yeah, it's their job to refute it, But the reality is the vast majority of them felt, I've got to convince them, though. It's not actually assumed that the alibi is true. I have to prove the alibi. It's not their job to prove it's not true. In fact, one respondent said that presenting an alibi, it may cause the jury to flip the burden onto the defense. Far too often, they reject the use of alibi defense out of a concern that it will cause the jury to flip the burden of proof. So prosecutors have to prove beyond a reasonable doubt that someone did it. If you raise an alibi, suddenly some defense attorneys feel it's now my job to prove I didn't do it. And that's just too risky. It's hard to prove you didn't do something. And I want you to just imagine this situation, okay? Your wife or husband or girlfriend or boyfriend or significant other in some capacity comes home and says, I think you cheated on me today. And you say, no, I didn't. And they said, okay, great, prove it. I'll give you a second to think about that. How in the world do you prove a negative? The defense attorney's claim, though, here is it causes us to shift the burden onto us to prove this negative, and so it might be better to just not use it because of that. Having a job and regularly shopping in the above-ground economy also greatly helped with generating an alibi. Defense attorneys liked that, right? We're glad that you have a job. We're glad that you shop at Target and you shop at Publix, right? Versus those who are unemployed or shop in the black market, right? You're like, well, no, I was buying drugs. Well, we're not going to bring that up, all right? That's not helpful, right? We're not going to bring in your drug dealer and be like, hey, will you testify that you were selling them drugs at the time of the crime? No, that's not helpful, right? And plus, a witness probably wouldn't do that, right? Because they don't want to get charged with the crime themselves. So one participant said, my retained clients tend to be employed and thus have a work schedule that helps establish timelines, locations, and possible witnesses. Also, my paid clients also generally live a lifestyle that lends itself to providing more possible witnesses that are willing to come forward and involve themselves in the process. Many of my appointed cases, right, so indigent clients, people that can't afford an attorney, have possible witnesses that may be helpful to an alibi defense, but those witnesses want nothing to do with the police, any investigators, the DA's office, or the court. For many of these people, nothing good comes from getting involved, even if it helps out a person that may be falsely accused. So basically, we're talking here about a wealth gap also in the kind of defense that can be provided, right? If I live on an island, I live on the island in St. Augustine in a gated community where I know all my neighbors. If I was with them, they would say, yes, I'm willing to help you out. You know why? The police never just drive through our neighborhoods. The police never just stop us on the street and say, what are you doing hanging out outside? In fact, the police don't even ever patrol our neighborhood because there's a gate, right? That's different and a different lived experience than other people who have the police driving through their neighborhood every day, sometimes multiple times a day, right? When the police come in, they might not leave alone. They might snatch someone while they're there for something and leave. There's going to be different perspectives on how involved people want to get in the criminal justice system when they have these different experiences. So this shows that those that are poor are, as is usually the case, at a disadvantage when it comes to alibi corroboration. Having a weak or uncorroborated alibi can even be used as a sign of guilt. In a court case, right, the opinion said there's nothing as dangerous as a poorly investigated alibi. An attorney who is not thoroughly prepared does a disservice to his client and runs the risk of having his client convicted even when the prosecution's case is weak. So not only are all of these issues with prosecutors and police and defense attorneys present, but there's also this issue of alibi notice rules. The defense is required to disclose the intent to use an alibi defense at trial. This rule arose to address the ease with which a defendant could fabricate an alibi midway through the trial. As is currently the case even in society today, we typically have these kind of weird reactionary things when something happens, right? So after World War I, a commentator mentioned without evidence that an alibi is one of the main avenues of escape for the guilty, right? This was back in 1920. World War I ended in 1918. And the basic suggestion was, all of a sudden, out of nowhere, they said, you can't convict me for this crime. I have an alibi. Here they are. And people were getting off for crimes, allegedly, that they believed they committed. So, currently 44 states, including Florida, have a rule, and the federal government also has an alibi notice rule that suggests you have to inform the prosecution and the court if you plan to present an alibi defense. Generally, the rules all have the same basic structure: inform the court of an alibi defense, provide the place or places where the defendant claimed to be and the time they were there, and provide the name, address, and telephone of any alibi witnesses that were present at the time of the crime. Now, granted, the rule also suggests prosecutors need to disclose alibi rebuttal witnesses to the defense because basically no side should be surprised by witnesses during a trial. As much as in courtroom dramas and on TV, it's like the surprise witness comes in at the last second and testifies, and it either convicts the person or gets the person off. That doesn't happen in real life, right? You can't just bring someone in off the street in the 11th hour, swing the doors open, and say, a witness is here. You can't do that, generally. The timing of the alibi notice, though, varies across jurisdictions. Some have alibi notice only at the prosecutor's request, others by the defense if they plan to use an alibi, right? And so there's some question about this. Now, Levine and Miller argue that there's some constitutional questions that are present by requiring alibi notice. The first concern is self-incrimination, right? The Fifth Amendment says you have a right against self-incrimination. The defense is not normally forced to disclose any of their evidence. It's the prosecution's job to do that, right? The state has to say why they think you're guilty. The defense doesn't have to say before trial why they think that they're innocent. The United States Supreme Court, though, rejected this argument in Williams v. Florida in the 70s as the defendant planned to bring the defense anyway, right? The court just makes you bring it a bit sooner. So basically the court said, look, you're going to bring this stuff up anyway. You're going to talk about this in court anyway. All the alibi notice rule is you have to bring it up sometimes as little as 10 days earlier, right? You're bringing it up anyway. You're choosing to bring it up, so you can't say it's unconstitutional. This, though, does not stop a defendant from taking the stand and offering an alibi claim. You can say, I'm not going to offer an alibi notice. I'm not going to tell the prosecution I plan on doing this. What I am going to do, though, is when I get up to testify in my own defense, I'm going to say, I couldn't have done it. I was elsewhere. The problem is, they can claim that themselves. They just can't call any witnesses or present any evidence to support that claim. Doing that would violate the rules. But that leads to the question of whether or not a jury would even believe this. Will a jury believe you've got no evidence to support you were someplace else, but you pinky promise you were someplace else? I don't know. Reciprocity is another issue. Basically, if the defendant turns over the alibi claim, the state must also disclose their intent to call witnesses to counter the claim. By not requiring reciprocity, a state would violate the due process clause of the Constitution. In states without these alibi notice rules, though, a judge cannot order the defense, but not the state, to disclose alibi-related evidence. So that's at least some helpfulness, right? The question, though, is what if after notifying the court of the intention to use an alibi, you change your mind and realize this is a bad trial strategy? Can the intention of use be used against the defendant? The Federal Rules of Criminal Procedure answer this question. Evidence of an intention to rely on an alibi defense later withdrawn or a statement made in connection with that intention is not in any civil or criminal proceeding admissible against the person who gave notice of this intention. So the Federal Rules of Criminal Procedure said, nah. You can't say they were going to offer an alibi and then withdrew it because clearly they know they did it. Not allowed to bring that up. What if the defendant's memory for their alibi improves upon further investigation, but after alibi notice is submitted? Can this be used against the defendant? And the answer is yes, it can. If you do an alibi notice rule and you tell the prosecutors, here's what we're going to do, here's what we say we are, and then you change your mind, the prosecution can use that to impeach a defendant and their previous alibi can be brought up to the jury. 6 weeks ago you said this, now you're saying that. Which one is it? Oh, it's the second one. Oh, convenient, it's the second one. After we investigated the first one and found out it was wrong? Therefore, attorneys believe it is ill-advised to file a notice of alibi too early, and 2/3 of survey respondents said they only file alibi notice with strong evidence. So 66% said that, compared to 25% who will file one whenever a client asks. There is also some trial litigation issues that are present, right? There are a few issues that a defense attorney needs to be aware of. One is, what if you know that the alibi is false? The second one is, what if you know or believe the alibi to be weak? Obviously, it's the defense attorney's job to vigorously advocate for their client's interests. But there's also ethical issues of lying to help a client, right? So what do you do there? Well, the rules are that an attorney cannot knowingly call a deceptive witness. If you know the witness is lying, you can't call them. Which is why oftentimes, if y'all ever watch mob movies, when they're in the attorney's office, right, to have a protected conversation of attorney-client privilege, and the mob bosses will start talking, the attorney very famously will cover their ears and go, la, 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 I can't hear this, because they could get disbarred for knowingly calling a deceptive witness, right? Now, how do you prove that they knew it or not? There's questions about that. But the model rules of professional conduct say that a lawyer shall not knowingly offer evidence that the lawyer knows to be false, right? If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. A lawyer may refuse to offer evidence other than the testimony of a defendant in a criminal matter that the lawyer reasonably believes is false. So the best way to avoid these issues are to ensure the attorney interviews and investigates the alibi claims themselves. Is this always practical, though? Do you always have enough time to investigate in detail every claim like Juan Catalan's attorney did in the Long Shot documentary you watched? I don't know, right? It kind of feels like it's not always practical. Neglecting to investigate or present an alibi, the defense counsel should make a judgment about using an alibi. But what if the defense believes the alibi is weak and the client believes it's strong? Could the attorney be accused of ineffective counsel if the client is upset? Maybe, right? To prove that, though, a client has to show the attorney committed an error so serious that it fell below the standard of competent practice and show that such an error was prejudicial to the client. In other words, had the error not happened, the client would not have been found guilty. Or the client would have been found not guilty. However, sometimes there's strategic advantages to not include the alibi defense. There's trial strategies to say, look, it's your mom or your girlfriend, the jury isn't going to believe you, we might as well not bring it up. Appellate courts have to distinguish between strategy and negligence then, and that also becomes very, very difficult. So taken together, all this kind of supports the idea that there's a lot to consider legally before making an alibi claim in court. As much as we've spent this whole semester talking about here's issues in alibis, here's issues, attorneys need to do this, attorneys should know that, attorneys should know this. Yeah, but there's also very practical concerns about making these claims in court. Governed by strict notice rules and subjecting defendants to the risk of impeachment if their story changes, the alibi defense provides very little cover for most defendants seeking protection, right? Defense attorneys must find an accurate alibi with strong supporting evidence that a prosecutor will not be able to impeach and that a jury will believe in order to successfully present an alibi in court. Whew. That feels like a very high bar, doesn't it? So Levine and Miller say this: for all these reasons, the decision to present an alibi is far from straightforward, and attorneys must develop intuition over time about the best way to proceed. The terrain is fraught with uncertainty about jurors' reactions to the evidence and laden with hidden landmines in the prosecutor's impeachment strategy. Hemmed in by notice rules and dependent on witnesses or evidence that might not be found or believed, the alibi defense thus resembles a mirage in the desert for most defendants in American criminal court. A mirage in the desert. You can see it out there, you know it's there, and if you get there, it could be your savior. But it always just seems out of reach. And this is why studying the law in theory versus the law in practice becomes so important. As always, if you guys have any questions, please feel free to drop them down below. Thank you so much.